Okay, folks, let's change gears. Let's talk about what's in a lot of the news these days. Special Counsel Robert Mueller and his investigation. Yeah, it's still hanging over the presidency of Donald Trump, and there seems to be no end in sight. Some people want no end in sight, or the end in sight they want is a hanging. Speculation has now turned to whether Mueller may try and charge the president with obstruction of justice. They seem to have shifted away from the collusion argument to the... So the argument goes obstruction of justice for firing James Comey or asking Comey to go easy on Mike Flynn. Could Mueller charge and convict Trump for these actions? Our next guest says absolutely not. Our guest is David Rivkin, a great lawyer, a great legal expert. David is a partner at Baker Hostetler, and he served in the administrations of Ronald Reagan and George Herbert Walker Bush. David, welcome back.
Well, great to be with you.
So, can a president obstruct justice in the exercise of his duties?
No. As a matter
Thank you, David Rivkin. We appreciate you being with us. Okay. No, we'll please elaborate a little.
Yeah. To elaborate a bit. Yes, the president cannot obstruct justice in the exercise of the core discretionary powers of his office. And the reasons for it, several-fold, and they all have to do with separation of powers. Basic principle, of course, of separation of powers, a great guardian of our liberty. In many respects, I would argue even more important, what's in the Bill of Rights, is that we have three coordinate branches of federal government. They're coordinate in a sense of independent and co-equal. And the basic constitutional principle is that no branch can act in a way that fundamentally curtails the ability of our branch to function. And it's important to underscore the framers were particularly concerned about legislative supremacy. That's clear in the debates during the Constitutional Convention in Philadelphia, clear in the Federalist Papers. So if we consider what would happen if Congress can pass a statute, or if you take an existing statute, and there are several statutory provisions in the federal code today dealing with obstruction of justice, and argue that the president is removing one of his subordinates, which would be firing Comey, or the president telling Mr. Comey to go easy on Flynn, supposedly, which is nothing more, constitutionally speaking, than telling him how to exercise his prosecutorial discretion, or the latest alleged nefarious act where the president, allegedly for White House counsel, urged General Sessions not to recuse himself. These are all perfectly legitimate exercises of president's discretionary authority. But what if done it, which is what the critics say, for nefarious motives? If you allow Congress to criminalize, either by interpreting an existing statute or writing a new one, these types of activities, that would effectively eliminate executive branch's co-equal status. And one of the things that that's worthy of note here, Congress already has an extremely formidable power of impeachment. Not easy to exercise, requires supermajority in the Senate, has some other important virtues like accountability, but it is the ultimate club that Article 1 can use against Article 2. So if you give Congress both the power of impeachment as well as the power to criminalize the discretionary exercise of core authorities of a president, the president would not be a co-equal branch. And what I argue in my Wall Street Journal piece is that this type of the presidential ability not to have his discretionary action scrutinized is very similar to what Congress has under the so-called speech and debate clause, or the immunity that courts, Article 3, enjoy in carrying out their adjudicative functions. I mean, each branch is expected to vigorously, Bill, exercise its core authorities. To exercise them vigorously, we need to have a sense, a strong and correct belief that they're not going to be prosecuted or punished for this. Now, the other reason to do that, so the first separation of power reason has to do with maintaining the proper balance between Article 1 and Article 2. The other reason is the inability of Article 3 of the judiciary to deal with those types of issues. And I can say to me, David, how is it possible? Judiciary routinely, in a variety of statutory context, looks into the question of whether something was done with nefarious motive or not. But what's unique here, if you think about it, the president is the only person in our governmental firmament who always wears two hats. He is an individual that has, of course, personal interest. He is also the chief executive. And how do you untangle, for example, if a president pardoned somebody or urged his subordinates not to prosecute somebody for personal reasons because he would be embarrassed, or because he feels that curtailing these measures is essential to the ability of his administration to function and carry out the will of American people who elected him. So we get inherently in matters that are political, and as the Chief Justice Marshall said in the very, very important early case, Marbury versus Madison, which, by the way, dealt one of the key issues there. Remember, that's the case they established judicial review or legitimated judicial review. One of the first questions is what is being scrutinized here, a political act or not? And Chief Justice Marshall said very clearly in his opinion that courts are not supposed to adjudicate matters pertaining or arising in the context of a political act. So you have a combination of, again, inability of Article 3 to adjudicate those types of issues and the need to preserve a balance between Congress and the executive.
All right, let me jump in here. A good analysis. By the way, the op-ed lays all this out. Can a president obstruct justice? Wall Street Journal, December 10th. We'll put a link up to it. Let's go back to the questions we're picking up on the media just to test out your hypothesis and with some simple examples. So the president decides that Comey, he doesn't like Comey, so he wants to fire him. He can do that constitutionally, right? He's not obstructing
Absolutely.
justice. All right. Supposing he says, I think we find out a conversation, whispered conversation to anybody in the White House. I think Comey's hot on my trail. I think he may try to nail me. I'm going to fire him. Can he be brought to a court of law on that basis? Is he obstructing justice there? Okay, supposing he sends a message through his White House counsel, what's his name, McGahn, and the message is tell Sessions to fire Comey because I think Comey's out to get me. Is he obstructing justice?
No, to underscore, it is what you do, not why you do it. The whole point is the exercise of discretionary authority to stop, to direct, to fire, to promote are absolutely immune from judicial scrutiny and immune from congressional regulation in the form of criminal statutes.
All right, let me test it one more time, which is we find out, we get a transcript of a conversation between among the president and Counsel McGahn and his personal counsel and the vice president, where he says, gee, I colluded with the Russians and I did all this, and I think Comey's going to get this evidence. Let's fire Comey. Can he be charged with obstruction of justice there?
No, but let me give you an example where he can be if he is telling, for example, the vice president or anybody who works for him how to slant their testimony of a meeting with Mueller. What I also mentioned in this op-ed piece that, again, it's not that the president can never be subjected to obstruction of justice charge. It all has to do with what action is he taking. So if a president is subordinating perjury, to use a fancy term, which is basically telling other people to perjure themselves. And perjury, of course, is lying in the context of you testifying under oath, or you can tell other people if they're not testifying under oath, but there's a provision in the U.S. Penal Code 18 U.S.C. 1001. You're supposed to tell the truth to investigators, even if you're not under oath. That's what Papadopoulos went down for. So if President tells witnesses who are not testifying under oath, but nevertheless subject to 18 U.S.C. 1001 to offer false testimony. Or if a president, for example, as President Nixon was accused of doing, he's talking about giving bribes to people so they keep their mouth shut. Supposedly he discussed this in some of Watergate tapes regarding paying hush money to the Watergate burglars. Or, importantly enough, and this
you could be charged with something there.
Obstruction. All right.
Obstruction.
Put it this way: there's no constitutional bar to being charged, or whether or not you should be charged or can be charged. And let me give you another example. If a president himself is testifying before a grand jury, for example, which I think would be somewhat difficult for me to imagine, but let's say if a president sits down for an interview with Mr. Mueller, in the context of his interview provides false information, then he may very well be charged with violation of 18 U.S.C. 1001 if he's put under oath of perjury. So it's not that he is God or he is a king. He is completely immune from reach of penal law. It has to do with, again, is he exercising discretionary authorities? And if you think about it for a second, Bill, he's exercising discretionary authority of his office. He is wearing the hat of a president. If he is offering people hush money or telling them to lie or perjure themselves, he's acting as a private individual because that's not part of his office.
How about go easy on my guy Flynn, Comey?
Absolutely no problem, because the entirety of law enforcement discretion that is vested in Mr. Comey and the Attorney General and everybody else in the law enforcement firmament is the president's in the first instance. We have a unitary executive.
Okay.
So the president is... Yeah. Go
ahead. That's fine. What about, let's bring it right up to date. I think this FBI... A business that was going on, these conversations with stores and the others is outrageous, and I think they've really tainted the FBI, and I want all of them gone.
It's nothing that doesn't even get close to. Not only he has the right. Well, look, civil service members cannot be dismissed, but for cause. But that's to the extent they're dismissed in violation of a statute. They have a statutory cause of action for back pay and reinstatement. But yes, if the president decides to clean house, he can certainly do that. Again, he is the chief executive.
All right. You are not only a brilliant lawyer, you're a large-minded citizen. Give me your judgment, your sense, if you're willing, of what's going on here. Did they find the collusion? The people who opposed the president wasn't going anywhere, so they've shifted to obstruction of justice, and it doesn't look like there's much there. Is that would that be a fair summary of what you think?
It is a fair. Well, we're reading tea leaves, Bill, and my hope is, by the way, it would not come to pass. To use an overused term, if Mr. Mueller would have charged the president for obstruction of justice arising out of actions we described, like firing Comey or telling Comey to go easy, supposedly on Mr. Flynn, or telling Mr. Sessions directly or indirectly not to recuse himself, or precipitate a constitutional crisis, would be totally outrageous. I would say several things. Look, I don't know Mr. Mueller. By all accounts, he's an honorable man. My hope is that he will not get there. The thing that surprises me a little bit, by the way, he clearly based upon all the leaks, he's investigating these issues. Now, if I were in his shoes, I would have first gone to the Office of Legal Counsel, which are lawyers at DOJ, and asked them for a legal opinion that I would very much predict would basically take the same position. So if you as a prosecutor are told that as a constitutional matter, no matter what the facts are, a given range of conduct, a given type of conduct cannot give rise to criminal liability, you should not criticize it. Apparently he hasn't done that. But again, my hope he'll do the right thing in the end. The danger here is Russian collusion, I think, is a joke. Russian interference is not a joke. The Russian collusion is a joke. We need a couple hours to discuss this. But the danger here is that he would be interviewed by Mr. Mueller.
Okay, what about
the danger? The danger of being interviewed in a situation where events took place a long time ago. you're busy, you're preoccupied, you're voluble, you tend to answer questions not in the shortest and crispest way, but you elaborate, is that he'll say something that may not be accurate. I'm not suggesting at all that he would do so deliberately, but there's enormous danger in having one's client interviewed by well-prepared prosecutors. So it is that part that troubles me. At the end of the day, I really do not believe that Mr. Mueller would come up with the constitutionally flawed obstruction of justice charge. But yes, you're right. It came up as a fallback, as a default, because the collusion narrative clearly has not panned out and could not have panned out.
And do you think there will be this in-person interview of the president?
Well, again, based upon various leaks, that is what Mr. Mueller is seeking, and I think it will be very difficult for the president's lawyers to resist it.
Okay.
And again, the narrative of the obstruction is what provides grounds for going over this terrain, because I mean the prosecutors have formidable rights to call people before a grand jury, or in lieu of that, it's called an attorney proffer, to sit down with them, accompanied by their counsel, and ask questions. But it must relate, Bill, to some specific charge. Since collusion is not panning out, I would say their obstruction narrative provides the context for such an interview, which is unfortunate,
but
to put it mildly.
But for the last 15 minutes, we've said there's doesn't seem to be much to the obstruction. It won't hold up if you're talking the exercise of his proper constitutional duties.
It is certainly my view. I think it will be the view of legal counsel. I think that's the constitutionally correct view. But what I'm saying, reading the tea leaves in terms of various accounts of interviews Mueller's investigators and colleagues have had with various people, he has not embraced this view, because he is talking, I mean, to put it very crisply for your listeners, he's interviewed people whose sole knowledge or sole set of facts that he's asking about has to do with the president's interactions, for example, with Mr. Comey, and has nothing to do with a collusion as such. So you ask yourself, well, it cannot be just satisfying his curiosity. It must relate to a charge. What is the potential charge? And the only potential charge I can think about that covers the individuals who have been interviewed who do not have any even theoretical involvement in the campaign or anything to do with Russia is the obstruction.
Right. And he does not, from what you reading the tea leaves, does not share your view, or perhaps may not.
Well, what he's done, and I don't want to leave it by saying implying that it's totally legitimate. What he is doing, which prosecutors sometimes do, he wants to assemble the facts and then look at the facts and the law to see if one goes forward. I think it would have been more prudent, more appropriate to first ask the question whether or not the charge can never lie, can never be maintained before investigating.
I got it. David Rivkin, thank you very much. Extremely helpful to us. Appreciate it very much, David.
Pleasure as always.
Thank you, sir. Bye-bye. All right, folks, before we go further,